I think fundamentally liability has a role to play in AI governance, but I would say the major problem that we have right now is that any liability, I mean, strict liability is what Gabriel favors, which I'll let him talk about. But even if we're talking about like SB 1047 style reasonable care liability, we don't know what constitutes reasonable care. For anyone who was at the Jack Clark talk, just preceding this one, that was kind of the point of his talk, is that we don't really know what it is to take reasonable care. If we're going to have open source models, what does that mean, right? Like, what do you have to do? Do you have to do something to prevent the safety, the safeguards in the model from being fine-tuned out, et cetera? Like, how does that actually work? What's technologically feasible? We do not know. And so the problem with liability at this early stage, I want to keep this stuff out of the court system for as long as I possibly can. And the reason for that is I think we will come to a dynamic where basically the future of AI policy is decided by a judge somewhere, like one judge, right? And like that's like, stare decisis is an important concept in American law. Let the decision stand, where we rely on precedent. And so like the way that software is regulated in the United States, for example, or the way that it is treated by the liability system ended up being quite favorable for software. But that was basically just due to like kind of random luck, like in a lot of ways, of just like how the court system internalized software in the early days. I don't really want to leave it to chance like that. I just think that's like really fundamentally irresponsible and a bad idea. So I don't think we should do that. I think we should keep major AI liability things out of the court for as long as we can. And, at some point in the future, like I think we'll have more evidence and it will start being more, we'll be able to reason about these things about like, really, was that negligent? Was that not negligent? But I think right now it's just fundamentally too difficult. So that would be my opening statement.
Great. So one note is that like, keep it out of the courts is an option. Like, people can sue, you can have a decision dismissing a case, but that does set precedents. But I agree with you that there's a lot of uncertainty about what mitigation measures are most likely to reduce risk and how big the magnitude of these risks are. And fundamentally, that's what I like about strict liability, is that to do most other forms of regulation, you need some level of social consensus about the magnitude of the risks. If you're going to do prescriptive regulation, you need to know what policies or what mitigation measures to tell the labs to implement. On the other hand, if you just say, well, you're generating externalities, we don't know how big those are, but some kind of risk externalities, when those are realized, you should pay for the harm you cause. You don't actually have to have the risks well characterized to commit to that principle. And so from a position of both like partially ignorance and to a greater extent social disagreement about these risks and how to handle them, and a position where to the extent we know how to mitigate these risks, the expertise is overwhelmingly concentrated in the private sector, shifting the onus to those private sector actors to find the most cost-effective ways to mitigate the risk and to only deploy systems when their social benefits exceed their social costs, when they expect to be able to make enough profits off of selling goods and services to pay for the harm they cause. That should guide their behavior. And so I think we don't have an alternative to making some kind of policy. I don't think you can avoid setting precedents. And the question is like what those precedents should be and what the right way to balance the risk and benefits are.
To me, the fundamental question though is like, what is causing harm in the context of AI, right? Like all cybercrime is harm downstream of the transistor, right? Like all cybercrime or of the internet or of computers, right? So like, but we don't sue, we don't sue Apple for cybercrime committed using Apple products. So like and I'm not saying that there's not there are definitely examples of, I can imagine things that would just be truly negligent behavior where, you can imagine a lawsuit being like a reasonable thing. But like, what does enabled mean, right? Like what does harms they cause mean?
Yeah. So a couple things to say. So first of all, strict liability does not mean absolute liability. It doesn't mean you are liable for anything your system was involved in. So in a standard negligence case, there's 5 elements: duty, breach, factual cause, proximate cause, and actual harm. What strict liability says is that when you're doing an activity that's subject to a strict liability regime, that substitutes for the duty and breach elements. You would still have to prove factual and proximate cause. Where proximate cause is is trying to capture the foreseeability of the harm. So I cut you off in traffic, you slam on your brakes, we don't collide. A mile down the road, you get sideswiped in an intersection. My negligence caused your injury, but no court is going to hold me liable for that because it's not the kind of harm that made it unreasonable for me to cut you off. That would still apply under a strict liability regime. The question would just be whether we're applying this narrowly scoped, was there some off-the-shelf reasonable precaution that you could have implemented that a reasonable person would have that would have prevented this injury? So to use another
this is your time to say.
It's fine. Yeah. We'll just
to use another traffic example, right? So if you run over a pedestrian with your car, right? In theory, we're supposed to be assessing the reasonableness of your conduct, but that's done in a very narrowly scoped way in a negligence case. So the court doesn't ask questions like, well, was it reasonable for you to take this car trip? Like, were the benefits to you worth enough to justify the risk to pedestrians? Or say you were driving an SUV, like, were the benefits to you of that worth the greater incremental risk from driving a heavier vehicle? Instead, it's questions like, were you drunk? Were you texting? Were you speeding? I just don't think that's going to be an adequate standard in the AI context, where the question isn't going to be, well, was it reasonable to deploy a model with these broad parameters given the current state of AI alignment, safety knowledge? It's going to be, well, was there some well-established off-the-shelf safety technique that if you implemented, that would have prevented this injury? If you think that's adequate, maybe you think negligence is a good standard. I happen not to think that.
Well, I mean, but very importantly, in the context of the car example, right? To your point, we don't sue if I hit someone with my car. We don't sue Toyota, right? We sue me, unless, of course, the brakes in my car failed, right? And that's because we have a very good technical idea. It's defined quite specifically in the law as to what constitutes a failure of a brake system.
Mm-hmm.
And so if the brakes failed, then perhaps, assuming my car was well maintained and it was just a true defect in the product, perhaps the person that made the brakes, or perhaps Toyota is responsible for that. But But in most cases, when you say I hit someone with my car, the implication is me. So my preference on liability is that we have a rebuttable presumption of user responsibility for misuse of models, because I think that the vast majority of sort of justiciable conflicts involving AI will be cases of user misuse of a model.
Yeah.
And so I just why do you disfavor that?
So, okay.
And I would also say one other thing.
Mm-hmm.
I also want, getting this right is an interesting intellectual question that one can do many workshops and panels and articles about, but also building AGI is important to me. And I would like that to happen expeditiously as is reasonable and safe. And so therefore I wonder if the liability question, if sort of does liability delay us meaningfully in getting to AGI, right? That's a secondary question. You don't have to answer that. I'm just saying that's a consideration that I have.
Yeah, so I'll address that first, actually, which is I don't favor a pause. I don't favor a policy to explicitly slow down for slowing down's sake. But I think there are circumstances under which it might make sense to go slower to be safe. And I think the point of aligning the incentives of the labs with the interests of broader society is that they go slower and take the time to be precautionary when that is warranted by a risk utility analysis. And so my goal isn't to get AGI as soon as possible. It's to maximize social welfare. And sometimes that might mean going slower. On your question about misuse, I think again, so I think the case for developer liability in misuse cases is messy. I don't think we can presume that the user misused it, but I do think it doesn't make sense to have as strict of a liability standard where the user either intended or reasonably anticipated the outcome. And I think at least as a if you were doing legislation on this, I think a first cut at it would say, well, if the AI system does something that would have been a tort if a human did it, and the user neither intended nor reasonably anticipated it, the developer should be liable, regardless of the care they exercise. Now, I don't think you should have a presumption there, but as in most cases, the plaintiff is going to have the burden of proof that wasn't true. So I think I'm not actually sure that a presumption would change things very much, but I wouldn't want to put an extra thumb on the scale to say the developer's off the hook there.
Let me make this like a little more concrete, right? Okay, so like, let's say that I use an AI agent to book me a flight somewhere, right? And the agent goes and books it, and it notices a bug in the American Airlines website, and it exploits that bug to get me a free flight, right? It steals a flight from American Airlines. It gets me to be issued a ticket, right? And it does that because it's a very clever and smart agent. I didn't tell it to do that. It just did that. I said, get the lowest possible price, right? And it said, okay, I'll do that, right? That would be a classic example of an alignment problem. In that situation, I can absolutely understand how like I shouldn't be liable for that, right? I don't think I should, as the user, be liable for something like that, right? That is like obviously on the person, the developer of that model, because like their model, you did this exploit. Now, on the other hand, like there's I think that's probably going to be, I don't know. I mean, maybe we just have very different models of how this all goes. I don't think that's going to be very common with actual agents that are used in production, because I don't really think that companies are going to ship such things, because I think they wouldn't be useful. I think they would be like gnats. I think they would be bad products.
What's the question?
Well, I guess I'm not really asking you a question. Go ahead. Yeah. I'm responding.
Yeah, we use that example. If the AI developer didn't necessarily do anything negligent in the design of the product, isn't it possible that like no one is liable? Like the user isn't liable and the developer isn't liable unless you have strict liability?
I mean, so no, like I think the developer is so I have a like long-term solution to this that I think is like much better, which is actually to do this under agency law, which is like a branch of the common law that is like, I hire you to move a sofa for me, and then you put it in a moving truck, and then you like went to a gas station and you got gas, but you also bought a lottery ticket, and then you like backed into a car and you caused, like, did you do that under my employ? And is that therefore like, do I, as the employer of you, bear some responsibility, or is that on you? We have a 1,000-year-old legal tradition where we have dealt with many, many permutations of problems that are basically of that kind. And I think that the issue with AI agents to me smells very much like an agency law, thing, more than sort of. So like that's kind of where I see, and I kind of think of it as being like that's what we should ultimately try to be building toward.
With agency law, because I'm not familiar with it, would the developer take on all the liability for things the agents do?
No, not necessarily. It would be that. So the thing about common law that makes it great and robust is that it's probabilistic, kind of like it's a little bit like a neural network, like because it's like it builds up over time. It evolves over time as a system. So like you don't like it is designed to deal flexibly with evolving and changing circumstances. So like the answer would be it would depend on this. It would be fact dependent.
Gabriel, would you like to?
The liability of the developer would be fact dependent. It's really all, but like that's all I can tell you. I can't give you a rationalistic top-down idea of like how we should deploy general intelligence and like mechanized intelligence into the world, of like how the liability for that should work. No one's going to be able to do that successfully. There's going to be too many permutations where it doesn't work. So the answer is like you have to let courts reason about it, and you have to just like be responsive to facts and circumstances as they arise.
Okay, so here's a hypothetical that I'd be interested in your take on. Say you get into a Waymo and you say, get me in the airport, I'm in a hurry. And it interprets this as, you should ignore traffic safety laws and run over pedestrians if that's what it's required to get me there. And, pedestrian gets run over, right? Who's liable?
Obviously, that's Waymo.
Okay. Let's say that during the training and deployment process, Waymo exercised reasonable care. There's
Well,
no specific precautionary measure that you can point to that would have prevented this injury.
Well, no, I mean, like, I just, what does that mean? Like, what is
What
like,
do you-
yeah, like,
What does it mean? AI safety is an unsolved technical problem. Just because you do all the reasonable off-the-shelf things doesn't mean your system will be safe.
but like,
That's the problem that I'm pointing out.
no, like but like rules of the road exist, right? Like,
Well, yeah,
there are
Waymo,
traffic laws.
Waymo did not violate the traffic law, right? The AI system did, right? But the AI system's not a person. You can't hold the AI system liable. What I'm saying is if the AI system does something that's a tort, the developer should be liable. But you wanted to reject that principle, I thought. So that's what I'm confused
Well,
about.
no, I think that I don't want to reject it entirely. That's what I said at the beginning of this. Like, I think that there are many areas in which it makes perfect sense to have a framework like that. What I'm saying instead is that most of the ways that I can imagine a language model being used in particular do not have the structure of like, don't have that same structure, because we don't have like rules of the road for how intelligence navigates the world.
Yeah, I mean, if we're talking about language models like purely in a chatbot context, I don't think they're going to cause the kind of physical injuries that would trigger, strict liability or negligence liability at all. So, I think we're talking about, where there's going to be the kind of physical injury that you would have a lawsuit over, or you would have like a negligence or strict liability suit over. It's going to be in deployment context where it's not just like putting out words.
Operator too. They're not just the
Yeah.
developer of the model.
Yeah, they own the car.
Operator of the car.
That's
Okay.
also true.
Okay, so say that it was licensed to a third-party operator.
Yeah, and the third-party operator would probably be liable, right?
What did they do that was negligent?
But just following the rules of the road, like Dean was saying, right? Like they would be like under existing automotive law. Like there's no like they would have the.
I don't think that's clear, actually.
You know what?
No.
Can we presumably not think of an example where something goes wrong, but there is a clear. Either Gabriel can think of one, or there are none, right? So what's an example? It hacks. You accidentally hacks a.
Right. So you have an AI agent that you instruct to like start a profitable business, and you give it no further instructions, and it decides to start sending out like phishing emails and scamming people on the internet. Developer liability.
And it was trained. There was no reasonable thing that the developers could have done to have like they tried to AI safety it didn't.
I guess like if you make a model where you say go start a profitable company and the model goes out into the world and breaks a bunch of laws and steals things from people, then like you probably haven't like, I think kind of just like definitionally you've kind of like
That's not how negligence law works. That's my point. Like,
Let's just pause. Like,
Yeah.
This is the central discussion, right?
Yeah.
Like, you think this is obviously bad. You think this is obviously fine.
I don't think that's fine.
no, I think that's unfair.
No, I
to
don't
you.
think
Yeah.
it's fine. Yeah.
Under current law, you think the law covers that situation. You think there's a clear-cut way that's going to resolve, and you don't.
There's like a factual question that's different than the normative questions. Like,
Mhm.
is there a liability vacuum from AI agents?
Right.
Right? And that's just like factual, regardless of what we do with that.
Mhm.
If it hacks a data center, if it blows up something in the course of its normal doing, you
I mean,
it's
I
clear
guess-
how the law will respond. You think it's
I guess like people use this example all the time, and I just don't really think it's all that interesting or like it's an interesting hypothetical, but I just don't think it's like all that useful because it seems so unlikely to actually manifest itself in the world. Like I prefer to think about like what are some examples of things that could like really like happen, and like cyber attacks would be one, right? Or various kinds of like data theft, things like that, right? Like you use an agent to sort of like hack a company or something like that.
Example of something that you are concerned.
Yeah. So I think let's get back to the misuse thing, which I think is where our bigger disagreements are.
Yeah.
Do you think there are never cases where a developer should be liable if their system is misused?
There are never cases where a developer should be liable.
So let's say the user is a terrorist group, right? And they are like, you can
yeah.
say they should be liable, but they're judgment proof, right? How should we think about whether developers should be liable for that?
I mean, again, like I would say that's such a high level question that it's like very difficult for me to give you an answer that's satisfying. And it's a question that is designed for me to not have a good answer to. It's a very
so like
lawyerly question.
AlphaFold 4 is out, right? And they can
yeah.
be used to build a bioweapon like really easily.
That's not the way AlphaFold 4 is going to work though, right? Like the problem is like you're asking questions about things that don't they don't quite exist in the way that you're describing, and they're not going to exist in the way that you're describing.
So a current organization.
Yeah.
I use like let's say OpenAI APIs, an agent framework to find an exploit in a large public company.
Yeah.
Or something else. Who is liable in this case?
Yeah. So right, like I did it, right? Like I directed the agent to do that thing.
No, terrorist.
Yeah. I'm a terrorist. I'm the terrorist, and I did that. Well,
Debate's
like,
over.
well, like,
He's a good terrorist.
okay, so like in that scenario, like, I mean, I guess I would say the terrorist is liable. That's obviously not that satisfying because you're not going to like sue them, right? But like, you know,
We have KYC laws, right? Like for violence.
yes.
So should like the juries be allowed to use it?
So, I mean, as a general rule, like I think that as systems become more capable, there will have to be like tiers of sort of like tiers of latitude that are given to companies, right? Like, or that are given to users, right? So it's like, of all the possible things you could ask a language model about biology, probably 90% are like completely harmless things that any person should be able to. I'm talking about a very capable system, right? Maybe 9.5% are things that like, well, a virologist can ask that question. A virologist that we trust can ask that question, but like maybe not like literally anybody can do, or like not, it's not going to be just asking questions, right? We're going to be, at that point, you're going to be talking about like automated research and things like that. Just a sec. 0.5% are probably in the category of like never, like that should probably like never be asked, right? So I guess I would say, yes, there are examples of misuse that I can think of that should just be like absolute nevers, right?
Liability for jailbreaks.
A liability for
Essentially, they say, okay, yeah, there's a secure system, but there's still jailbreaks.
again, you got it. Like these things are going to be fact specific, right? Like I just can't.
Super specific.
Yeah.
Very actionable thing before it happens. So I don't understand what you
What do you mean?
as in like we already have systems reasonably capable.
Well, no, because again, like the question is not going to be like the concept of a jailbreak is an enormous one that contains a huge number of possible things that could happen, right? And so the question would be like, well, was this a type of jailbreak that was well known in the field? Was this the kind of thing that like you could have, theoretically like done something about, right? Was this
That's exactly the problem from my perspective, which is like if there isn't a thing you could have done that and if it gets jailbroken, catastrophic harm happens, you shouldn't deploy the model. And under existing negligence law, that's not inside the scope of the analysis. That's the fundamental problem. So like, yeah, there might not have been some technical fix, and that shouldn't mean you escape liability.
right? But the problem. Sorry, go ahead.
I was going to say, I think Dean would take like the control of it has like shifted one way, so I might just like reset and say like you can respond to this, or but like also you can leave for a couple.
I don't care. I'm happy to answer questions about this. Like, so I think like it will just like it's just going to depend on like specifically like what kind of a jailbreak was it? Was it one that required like an enormous amount of effort that no one had ever done before? And if that's the case, then like, yeah, I don't really see why OpenAI should be liable for that. I really don't.
So you don't think they have it that like that society should care about tools being put out there?
I didn't say that.
Well,
I didn't say that at all. I said OpenAI should not be responsible for it. Should not be legally liable for it. Yeah.
I think one problem with that approach is that it kind of doesn't incentivize finding safety solutions to some of these problems. So if OpenAI was liable for something that goes wrong in a case where there isn't like a way to fix that thing, they're now incentivized to actually like find a lot of solutions.
Well, wait, but like I'm positing that there will be. I might be more of a doomer than most of the people in this room in the sense that I am positing very clearly. I want to say I am positing that OpenAI is building things that may well have exploits that no one can do anything about. That could result in very dangerous things. I don't really think it's all that likely that like the intelligence itself is going to result in the catastrophe. And I think there's like, between like, I mean, I think you will get to 95%, 98% success But there's a really big difference between 99.9 and 0 or and 100. You know, there's a huge difference. All the difference in the world between those two things.
Maybe this is like thinking on a slightly different track, but like governance as a mechanism for incentivizing.
Yeah. So
safety.
100%. We're in a total agreement that governance is the way to do this. Like, or that we need gradients that incentivize, you know, good behavior. Markets are a really good gradient for certain kinds of things, right? Like markets are really good, and markets are underrated by most people in the AI safety community. And I think that's like fundamentally just a difference of opinion that I have with many people.
Markets are great. They don't handle externalities very well,
Yeah.
right?
Well-
and so fundamentally the problem here is if there's harms to non-users, right, that are internalized neither by the developer nor the user, right? Like
Which is why there was a comma after what I was just saying, like that like markets are one thing that do a lot and they do more than you might think, but also I do think there are other ways that we have to sort of price risk essentially. And I would say, like, in general, I'm bullish on America's ability to do this. Like, America prices risk better than any other country in the history of the world. And so I think that, like, we will have good mechanisms for doing this. I tend to think that the pricing of risk for AI uses and, you know, like both mundane and catastrophic types of risks will be better situated in, like, probably private governance organizations, something that looks like insurance or something that looks like third-party metrology, kind of. Like that is what I am more bullish on than I am the court system figuring this out in a way that is actually productive.
I think insurance is great. I don't think you have an incentive to develop that market unless you're liable for the harm. If it's externalized, then there's no price discovery.
Well, yeah, you have to create an incentive for that market to develop, for sure. I agree with that.
Kathan?
Yeah, I was just going to say, like, the way that the liability system works, almost always, is not that you litigate a case through to final judgment. It's that the threat of that kind of provides the necessary incentives
100%.
to create a scaffolding in private governance, the kind that you favor.
Yeah.
Which is why it's a little bit, you know, I'm curious when you say that OpenAI should be responsible in your hypothetical. One way of understanding that, which I might agree with, is that if OpenAI is taking all due care, it's made a reasonable release decision, which I do think is kind of picked up by the management standard, but that's a really in-the-weeds debate that Gabe and I can have. And the benefits outweigh the risks, then even if that risk materializes, well, then maybe OpenAI should not be liable because you don't want a company internalizing all of the costs of its products without also internalizing all the benefits and management standard.
Mm-hmm.
Sure that. So if that's what you're saying, I think that's plausible. But I think the way some people have interpreted you, and I wonder if this is a correct interpretation, is that they should just be categorically immune from liability, even if they've made an arbitrarily irresponsible release decision.
No.
So
No, not at all.
I think that maybe your view is not that you don't want liability, it's that you don't want Gabe's particular proposal, which is strict liability.
That's correct.
Okay.
Yes, that's correct.
So great. So that's helpful because I think that means
Yeah, like, I mean,
less disagreement.
if Apple ships me a laptop that the lithium is leaking out of the ports, then like I think that Apple has made a mistake. But if I, if I on the other hand use my laptop to commit a cybercrime, I don't think Apple has done anything wrong.
But see, that's not the same as that's not a breach consideration. You're talking about like
I get it.
Yeah.
I'm just using an example.
I think this might be above my head. Maybe it's that. Can you explain? So maybe in Gabe's example, it's the courts who decide exactly the price of each bad behavior because it's strict.
Yeah.
If you think there should be some government, some tiers of things you can ask, or there's some bad behavior that's priced that, who decides that?
So let me who decides that price is you would have a market based some sort of
The price of the bad behavior. The market doesn't decide that. You're saying that there's things you either can't.
Well, you price the risk. You price the risk.
Go the other way. You have these things that you can't ask a model about biorisk stuff.
Uh-huh.
The 0.5%. No, who decides that 0.5%? Like that's a government tool saying you can't consequences.
Yeah, that is a matter of like very, very careful measurement and evaluation.
Clarity, you
Yeah.
think that would be sort of less regulatory in some sense for governments to decide that thing than for the courts to decide
I think
the liability?
there is an approximately 0% chance that governments or courts will figure that answer to that question out.
So I think
0%?
so. The way I think to get the outcome that you want is to say, well, OpenAI is liable if this happens. That gives them the incentive to create robust checks that make sure that the 90, like for the 90%, that's fine. For the 90, like the way you align their incentives to get that outcome is by holding them responsible when it goes wrong.
Right. No, I understand what you're saying. I think that the way that doing your proposal, like, would, I think, give far too much power to the court system.
And you would like to give power to who instead?
I would like to give power to a private governance regime that is basically like stewarded by the federal government, kind of like, like instantiated by the federal government, but ultimately like a private governance.
This
regime.
is like when people set up like privately run carbon markets, right? And then they fell apart because there was no like regulatory stick to it, right?
Or like when insurance markets have existed for 700 years, or
insurance.
like,
Insurance
right.
is either for risks to yourself or to risk that you know you're going to be liable for, right? You don't buy insurance against things that you're not going to suffer from. And so why would OpenAI buy insurance if they're not going to be liable?
Yeah, so it's not exactly insurance that I want. Anyway, I don't want to, the thing is this is a debate about liability. It's not a debate about what my proposal is. So yeah, like.
At this point, if you want to jump on the second question, which is about punitive damages for near-miss cases, you can. I think this is kind of interesting. So
I mean, I will just say on the near-miss case thing, like on the strict liability side of things, like we're not as far apart on that issue as like you might think. You know what I mean? Like we're really not. It's just it's kind of more about order of operations for me, because I am very cognizant of how of how precedent dependent our system is, and I think making highly consequential decisions when we have approximately no information that is relevant to reasoning about these matters is a bad idea. But the near-miss
There's no way to avoid making those decisions. I just want to be clear about that. If a court gets a case, they have to decide it some way or another.
I think this explains it. Dean,
Yeah.
do you think you could teach Gabe to explain your point of view? Because I'm not sure that most of us really could say the thing that you.
Well, because the thing is that we're not talking about we're talking about Gabe's proposal, not my proposal. So yeah.
The reason you don't like Gabe's proposal, I think maybe some of us don't understand.
I see. Got it.
Importantly, it's not you have to understand, it's us, or at least him.
Right.
That's pretty helpful to talk through, like, kind of what I feel like we're hearing a lot of worst case scenarios of like, you have the thing, it breaks all the laws, it kills all the people, but I think you probably have like a worst case scenario of like, you have a bad case, it restricts a bunch of stuff, you don't get to take advantage of good things, there's a huge chilling effect.
Yeah.
Like, could you talk through your worst case scenario?
Oh, I mean, basically be like exactly what you just described. And like it also, I mean, the other thing is that like, so the way that courts will reason about this stuff now is going to be based on the body of soft law that the Biden administration has produced in the last 3 years, which consists of the AI Bill of Rights as a foundational document and the Risk Management Framework as a foundational document. These are documents that say, basically, you should do everything about every possible risk that could happen at any time to anybody. And that does not make for the foundation for a solid foundation for like how companies should actually be reasoning about these risks.
Isn't there an explicit disclaimer in the AI Bill of Rights? Like, is the courts rule on the basis of that?
They could. Like they do. Yeah.
It wouldn't be negligence per se, right? But it could be like something that courts consider. And
Yeah,
like
they
that,
could.
right?
It would be some. It
could be persuasive evidence.
Be things that they consider. Yeah. And by the way, there are currently groups trying to get the FTC to enforce the RMF as a law.
Right.
Yeah.
So, would you endorse that happening with this body of quite soft law?
No, I mean, that's pretty incompatible with strict liability, right?
So
Yeah,
what
so-
you're saying is that you think Gabe's thing is going to be a Trojan horse for something that he doesn't endorse.
I mean, yeah, I think that's a great way of putting it. Yeah, I think that the way that it would work by default would be that we would have a sort of like out of control litigation.
You don't disagree on a sort of like theoretical, like you just disagree with practically what's going to result from it.
I would say Yeah, you know what? I got to tell you, like, I'm not sure on the theoretical side. Like, I'm not a lawyer, right? Like, so it's like hard for me to tell you like whether or not like I actually to what extent I really disagree with you in like a grounded theoretical way. It's more about practical, just like order of operations. But I think I do disagree with
And
you
again,
on
I
the
don't think we have a
theoretical side.
choice about the order of operations. Like court gets a case, they have to make a decision. Like that's, yeah.
Not necessarily true.
Let's imagine that he's right about the thing. Can you build a regime in your head right now that would somehow circumvent what
I mean, I think my regime does circumvent that, right? Because the existing negligence regime requires you to decide what the standard of care is. The strict liability doesn't do that. It's an end around like precisely the concern you have. It's, if there isn't this, so a lot of the criticism of SB 1047 was like, oh, can you comply with this? Is it too hard? Who even knows what reasonable assurance is? Like, I didn't find that all super credible, but like, there's no compliance with the strict liability regime. You just pay for the harms you cause.
So like what would be the lowest level thing that like the smallest possible thing that a model could do that somebody could sue OpenAI for in your world? I want to try to get a sense from you of like how much incoming should OpenAI expect if your proposal happens?
I mean, it depends how much harm their system does. It has to do
GPT-4o
is to do like
systems today.
I don't know that it's caused any physical injuries that would qualify. I don't expect current systems to be doing that much harm.
Broken arms, right? Broken arms enough. A single broken arm and they're getting an email.
Correct.
Is that an answer to your question?
So okay. So I just want to be clear.
Physical injuries aren't just bodily injuries; they can also be like property damage. But yeah,
But you're talking purely about physical injuries.
Yeah.
Right. Okay. Cool. Got it. I just want to be sure. Okay. So basically none right now.
yeah, I don't think there's any right now.
Yeah. Okay. Charles.
So at some point, it seemed like there was an agreement between you two that insurance or like part of market mechanism like insurance would be a useful mechanism to have in place to mitigate harm. I think I have a clearer sense from Gabe about how his proposal might enable that. Do you have like a sense of like, is there a way to get that goal of a kind of market without needing to change the liability regime for sure?
So I think from my perspective, I think that again, I think we should have a rebuttable presumption of user responsibility, right? Sorry, yeah. Yeah, so basically like a company deploys a model in some context, right? And like it causes, and you're thinking about this more in terms of physical and like bodily harm. I'm really not, to be honest with you. I'm really not, like, I don't think that's not really like at the top of my concern list, right? Like I'm much more concerned about other things. Like I'm not worried about a language model directly killing me. So
the kid that killed himself, the kid was chatting with the virtual girlfriend.
That's a great example. Because there's really not a lot of good evidence that like the model actually contributed to that kid's suicide. And there's a lot of facts about that kid's life that seem like they probably contributed quite a bit.
And to be clear, I'm not sure I think liability should attach there. So like the standard I laid out was like, if the system's conduct would be a tort if a human did it, talking someone into committing suicide is not actually.
And the model did not talk to kids.
But I'm saying, even if the model did that, right? Like that's not actually a tort. We have.
The lawsuit alone is causing a lot of like kids.
Well, like what they're saying is
Right,
that,
but under my proposed legal standard, like the plaintiff should lose that lawsuit is what I'm saying. So like, someone can sue under any legal standard, right? But
what they're saying though, in the theory of that case is like the company was negligent for making chatbots that simulate erotic exchange with children, which like, I mean, I just said what I just said, right? And those are the cold hard facts of what happened. So I mean, like you can talk about that in a moral sense, right? For sure. But like, I just don't really know that like contributed to the child's suicide.
I think before we take more questions, I just want to put the punitive damage stuff on the table.
Yeah.
So the core argument here is like, well, part of what I'm concerned about are large scale risks, right? Obviously, you're not going to sue over the end of the world. You're not going to sue if the courts are no longer functioning. If your system kills 1 million people, does $10 trillion of property damage, you're not going to be able to enforce compensatory damages judgment for that. It's going to exceed any plausible insurance policy. It's going to bankrupt the company. And so if we want to internalize those risks using liability, the only way to do that is in the counterfactual where they're not realized. That's the motivation for the proposal. If you're not going to do that, then you're going to have to rely on other regulatory tools.
Yeah.
And I think for reasons that you and I agree about, liability is a better mechanism for motivating the right precautions.
Let me try to say it as clearly as I can, like where I think the fundamental disagreement is I don't understand what a model causing harm in the physical world means. I don't understand what that means. And it sounds to me like the kind of thing where, if you told me the story, it would be a little bit like the character AI thing where I'm like, well, the kid was definitely in love with the chatbot and the kid definitely killed himself. But and I think that the people, the company that made that model, they didn't do what I would have done. I'll say that much. But at the same time, it's hard for me to say that the character AI chatbot killed that kid. And so that is where I think we will run into problems with what you're talking about, because it just sounds to me like a lot of the kind of physical harms in the world, major large scale harm is typically accomplished by it's a lot of different things all at once, right? It's a lot of different, tools that are being used all at the same time. And it just seems to me that this is going to result in a lot of things getting blamed on AI that aren't necessarily the fault of AI per se. Yeah.
Are you including this? If it make API calls, is that a separate thing? You're not including that, or?
Again, it would kind of depend, right? For example, if it's making API calls to a cloud lab, for example, and let's say that cloud lab is regulated by other laws, in the it could then for example, then the cloud lab might bear responsibility.
I mean, in terms of you saying you can't imagine how it would cause physical harm.
Oh no. So yeah, I can imagine it actuating in the physical world in that way. But what I'm saying is in that situation, I would think that the cloud labs themselves would be regulated and would probably have some sort of KYC type of provision. And so if a model that was acting maliciously, did something, then it might not. Anyway, I was just trying to describe where I think the liability might kind of attach. Yeah. Oh, sorry. You've had your hand for a while. Sorry.
Some of your disagreements for both of you seem to be about what the incentives, setting up the incentives properly for the labs is.
Mm-hmm.
So the risks we're really worried about under current law. I'll ask Gabe. Under current law, what do you think happens to OpenAI? Right. I don't mean just legally. I mean just socially. If they release a law, someone created a bioweapon and killed, forget 1 million people, killed 1,000 people.
Mm-hmm.
What happens to OpenAI in a company?
I would imagine they get some blowback for that.
OpenAI, you do not internalize that incentive function under existing
But it's the other way around, right? If it kills 1 billion people, it doesn't matter whether
Yeah.
But if it's 1,000, 1,000 is a more interesting number in that regard. Yeah.
Right. So there are certain risks that I guess what you're saying is PR is doing some of the function of internal.
The vast regulatory state would come down on it, whatever the existing law is.
100%. Well, this is also I just as a.
And they know it, right? So,
as a side note on the sort of open weight, Mark Zuckerberg, is Meta going to release Llama 5 or whatever? It's if the government's really, really, really super duper concerned about Meta open sourcing Llama 5, they will just bully Meta into not doing it. You don't need a new law. They will just bully them. 100% that's what will happen.
So people that's not your reaction. For this threat factor, why do I need extra reports? What's going to happen under current law, under regulatory regime?
Well, you're talking about emergency powers or whatever being invoked.
Not emergency powers, just all the crap the regulatory state can throw at you.
But you're not saying you support that, right? So I don't know.
I'm saying I live in the United States of America.
Right. But I'm talking about what policy should be, and you're saying, well, we don't need good policy because we're going to do bad policy instead. And it's I don't know, man.
No. That's not what I'm saying. I'm saying what you think that if we have a strict liability regime, the administrative state goes away, lawfare goes away. I tend to not think so.
I'm going to give a minute each to
cool.
close up. So if you'd like to start, Dean.
Yeah, so like I'd love to at some point like give my broader like summary of how I think this should actually all work. But really, I think our disagreement comes down to my deep skepticism that courts would internalize these questions in ways that produce reasonable outcomes. And I think that like the long-term governance is going to look nothing like what any of us are, including myself, are envisioning today. Like it's going to be so different, I think, in 15 years from what we can currently envision. But sometimes that makes people think like, oh, it's not very relevant what we're doing right now because it's just going to be so different in the future. I think actually it's the opposite. I think this is an incredibly high leverage time because I think that the long-term regime is going to be very sensitive to the initial conditions that are basically going to be set in the next 12 to 18 months. And I really don't trust courts to get that right. I love courts, by the way. I love the legal system, but I just don't trust them to get that right on this specific question.
I'm a simple man. I see a market failure, an externality. I want to
There is no market failure. Nothing's happened yet.
Okay, so there's an uncertainty about the risk. That's why we're not doing an AI risk tax, because you can't measure AI risk ex ante, right? My background's in climate change law. I think what we should do is a carbon tax, is we can measure like your contribution to climate change. On the other hand, we can't like say you driving your car on this day and emitting some CO2 caused this flood in Bangladesh, right? So we can't do climate liability. We can do AI liability. We can say that this system was used or was misaligned and caused this harm, right? Like cause is not. It's like, I agree, like being an instrumentality of something, it doesn't mean that you caused it, but we have a well-established doctrine. So you've given these paeans to the common law, right? We have a very long history of courts figuring out what it means to cause something, both factual cause and proximate cause. I'm not saying we should change any of that doctrine. We should bring on all of that. And I'm just saying that the breach standard, the narrowly scoped breach standard that applies in negligence cases is going to be inadequate when we have an unsolved technical problem and we need to push the ball forward, to push forward the frontier on safety, not just to encourage the deployment of existing well-established techniques.
Okay. Well, thanks very much.